Good afternoon and welcome to our panel sponsored by the Web Foundation. The Web Foundation is a foundation created by the web inventor, Tim Berners-Lee, and it works in three streams, one dedicated to voice, one of participation, and one of access to the internet. And as a top of the priorities of the foundation is to develop not only to oppose to current problems and issues, emerging issues in legislation and in policy affecting the open web for all, but we also are concentrated in proposition, in trying to find a positive agenda that we can push forward and to try to find solutions, viable solutions to fix the current problems threatening human rights in the digital environment. And as part of this process, we have been participating, and Sir Tim Berners-Lee has been very vocal against surveillance from as early as the problem emerged, but the difficulty that we have faced in the last 4 years is constant opposition to different laws that proliferate everywhere. And as we learn more about the problem, we realize that at the core of the problem is an increased power and as they never had before of the intelligence services and the intelligence agencies as a parallel state within the state that is unaccountable, and it is very powerful in ways that we cannot see. And not only the UK with its problem with secret laws, but it is not only an EU problem, the one that we are facing. It's a problem, it's a democracy problem that we are facing globally. And allowing those abuses to continue for the sake of a false sense of security and allowing those powers to increase will put not only our security and our privacy, but our democracies at jeopardy. So the foundation, we have engaged in and still ongoing research project in different jurisdictions because we want to stop complaining about how powerful they have grown and how big the threat is, and we want to move to look into can we fix it and can we propose a set of practices and solutions to limit the powers, make the intelligence services more accountable, and make the whole process of surveillance taking place in any given country and the cooperation among states more transparent, so for citizens to exercise some sort of control. So we have this brilliant panel. It is a mix of academics and activists, and the emerging hybrid of the academic activist, as I will describe some of the members here. We have Dr. Powles from Cambridge University. She's even three things, I will say, because she's not only a brilliant academic, but she's also an activist, very vocal for civil liberties, and she's also a journalist, so we have 3 in 1. We have Dr. Wagner from Germany and the UK, who is currently head of the Center for Internet and Human Rights. And I will place him in academic and a little bit activist from the table. And we have a very senior professor from the Metropolitan University of London, Dr. Douwe. I think that his voice will be very relevant for this panel, as he will bring us all the experience in the criminal field. Dr. Ian Brown, I do not know if Dr. Brown is more an activist or an academic. I'm thinking that one day he will quit academia and just go all the way activist, or the other way around. I secretly hope that happens. And Agnès de Cornulier She has battled the giant of the surveillance state in France, and I think that it is the most recent experience fighting this and trying to fix something, and it will be very, very insightful for us. Before we start, I mean, it is urgent that we at least have one thing to fix and one battle to win in this. Just yesterday in Austria, new surveillance laws were approved, giving even further powers to the intelligence services. And in Poland, there's a new law being pushed forward. And in Latin America, there's a big effort to give even greater powers under the excuse of, El Chapo, war on drugs, to have even more powers. And it's the same situation in Africa and the Middle East. So without saying more, give the floor to the moderator, Dr. Wagner.
Thanks for the introduction, and we're very sorry that Frank Claroux couldn't be here today, but sadly he wasn't able to make it, so we're very grateful for Ian Brown for jumping in at the last minute. And also, I'd just like to emphasize that this is meant to be an interactive panel. That means that we're going to keep our presentations as short as possible, and we're dependent on you. That's everybody in the room, explicitly everybody in the room, because we're at CPDP, there's lots of knowledge, there's lots of ideas, there's incredible participants in all of the workshops here. And so we'd be very grateful if you're loud and vocal and honest about how you feel about many of these topics, simply because we can only provide so many perspectives, and we realize there'll be many more very valuable perspectives in the room. So without further ado, I can pass the word first of all to Douwe, and then we'll move on with the further speakers. It's all yours.
Thank you, Ben. Well, Ben and I and Julia have been working hard at looking at various surveillance laws with other people. Ian and I have been doing quite a bit of work at this as well. I will stick today to the core issues before the others will look at more specific surveillance laws. I should also mention that more will be published fairly soon, isn't it? Yeah. On the specific work we've done. So I'm not going to give away everything, but I'm going to hopefully give you something to think about, and more importantly, like Ben said, something to get back to us on. So I'm going to make some, I hope, challenging remarks. Let me start off with Field Marshal Montgomery and his traditional statement of the view of spying and the clandestine services, which is that they're outside the law. They're clandestine, they're outside the law. There might be ghastly, there might be things that are abhorrent to civilized society, but civilized society just turns a blind eye. That is the traditional 18th, 19th century, early 20th century view, right up until the Second World War, and including the Second World War view of the secret services. Historically, it's important to realize that. That is the way it was perceived, that is the culture in which they operated. That continued through the Cold War, when the KGB and the CIA were doing all kinds of nefarious things behind the scenes, bumping each other's spies off. And as long as they were only killing each other, the rest of the world didn't mind too much. I think it is time we move on from that. And there are, how do I get to the next slide? Yes, there are three main reasons why. First of all, in the digital environment, cross-border collection of information is increasingly infringes on the sovereignty of other states. Like I said in the previous slides, I do not accept, but I'm happy to hear contrary views, and I know Professor Deeks has come up with contrary views there, that international law permits spying outside of armed conflict. When states are shooting at each other, when they're in conflict, when there is war, everybody accepts that they're also allowed to spy on each other. Outside war, it is not accepted, even if it happens on a great scale. For those of you who know public international law, there may be a widespread practice, but there is no opinio juris, in my view, that spying outside of war is legal. And in my view, it's an infringement of the sovereignty of other states. In a way, more importantly, the activities of the security services are increasingly closely intertwined with those of the law enforcement agencies. And the danger there is that the illegality, the dark hole of legality, that has surrounded the secret services will spread to law enforcement agencies, and I believe that is exactly what's happening, and it is a threat to democratic society and the rule of law. And thirdly, very basic principle, if you look at the International Covenant on Civil and Political Rights, European Convention of Human Rights, and other international instruments, it is a fundamental principle of the rule of law since the end of the Second World War, since the creation of the United Nations, that all state activity must be subject to the rule of law. So the question is, how are we going to bring the spooks within the rule of law? Well, there are a variety of systems of control and oversight. And what I've done here is very briefly list them, and the list comes, you see the reference at the bottom from Aidan Will's summary in an issue paper for the Commissioner for Human Rights of the Council of Europe. These are the sort of recognized forms of control that you can have over secret services, and they all have their drawbacks. Parliamentary committees of oversight, they can be captured, and if they're appointed by the government, for instance, they have limited democratic legitimacy. They lack expertise, politicians tend to lack expertise, and very often they don't get full insight, and that's one issue to which I'll turn in the next slide. Independent committees, so-called independent committees, can of course equally be captured, again, especially if they're appointed by the government. Judicial bodies, which is in a way the preferred method of oversight in terms of international human rights law, it's what the Strasbourg Court has said is the preferred method of oversight. There's a problem with it, that if you make the law very loose, judicial oversight becomes meaningless. If the law says you can do whatever you like, and you do whatever you like, then a judge checking whether what you're doing is legal can only say, yes, he's doing what he likes, therefore it's legal. Or to put it a bit more simply, if the law, such as typically UK law tends to state, says something like, if the Secretary of State believes that a person is an enemy alien or whatever, I'm actually quoting Regulation 34B, I think it was called, the Second World War, then the only task of the judge would be to check whether the minister was completely mad when he made that determination. But as long as he wasn't completely off his rocker and or completely corrupt, that determination stands. So judicial oversight is really determined by the substantive law and, of course, by the standard of oversight. In the UK, they're proposing now a form of oversight that is similar to judicial review, which in English law is quite limited. But I won't go into the technicalities. Anyway, judicial oversight depends. Oh, and the one thing I added here is that if you have, if there's little insight into what the secret services are doing, supervision by definition becomes limited as well. I'll come back to that on the next slide. Quasi-judicial bodies, these are the new kind of bodies that are being set up. They've tried it in Belgium. Aidan Wills thinks it's a good idea. I have my doubts about it. They basically suffer from the same kind of expert appointments that you saw elsewhere. Internal control is not oversight at all. This is simply saying that the political masters should have sufficient control over the security services to make sure that they don't go completely wild. Of course, that's necessary, but it's not oversight. Complaints mechanisms, well, they're not very useful because by and large the complainant doesn't get much insight. But at least if he can complain to a proper oversight body and the oversight body has good access, then there might be some merit in it. We come to the crux of the thing here, which is transparency, which is exactly what Ben and Julia and I have been looking at. To what extent do even the oversight bodies have real insight and real technical comprehension of what the intelligence services are up to? And we have found, I don't think I'm giving away too much yet, that by and large this is quite bad. That the data that comes out is very bad, certainly the published data, but even the information that is provided to the oversight bodies is very limited. One particular problem Aidan Wills recognizes and the other experts on intelligence service recognize is the third parties rule, whereby if country A gives intelligence information to country B, and country B is bound not to reveal that information to any third party. And that is sometimes and often interpreted as the intelligence agency of country B is not even allowed to show that information to its own oversight body. In those circumstances, the oversight body cannot exercise its function. So that's a rule that definitely needs to be changed, and the Commissioner for Human Rights in Strasbourg has recommended that. So, the proof of the pudding are the national and treaty rules, covering the activities of the national security agencies public, clear, precise, and foreseeable. Any European human rights lawyer in the room knows that those are the European tests. Second one, is there meaningful transparency about the way the rules are applied? I mean meaningful public transparency. And thirdly, does the oversight system actually prevent illegal or extra-legal activities by the agencies? And that includes activities that nobody realized were legal. Secret interpretations of law are also not law. Well, the answer, without giving away too much, to all three issues is no. Not even in the Western, supposedly rule of law-based democracies. There's extensive secret law, that's not law in the ECHR sense, including secret annexes to treaties. And if you want to have a look at Foschepot's study of Überwachtes Deutschland, with a very good overview of the German treaties, and it's a special interest case for those of you who can read it. Published information on practice is not meaningful and not transparent and not honest either. And finally, the national security agencies in too many countries, including supposedly rule of law-based Western democracies, have been exposed as carrying out activities that nobody thought were legal, let me put it that way. Either because they interpreted the law behind everybody's back in a way that nobody knew about, and then did things that they claimed were legal, but no lawyer, if you'd asked them a year earlier, would have said it was legal. Or because they were straightforwardly doing things that they were not authorized. And that has happened in countries like South Africa, France, Germany, the UK, and the USA. And if you look outside our Western little clubs, things are worse. I hope I can leave it at that.
Fantastic, thank you very much. So I hope that provides a general overview of where things stand, and we'd now like to move to the specific French case to provide a little bit more concrete of what it's like on the ground as an activist dealing with all of this.
Okay, so I have 8 minutes to show you how France has become the fate of Europe and has become now a sort of police state. So more specifically, I would like to show the legal framework of surveillance in France. So until last year, we had only a law from 1991 that focused only on phone interceptions. So it was nothing, but it did not prevent, of course, the intelligence services to work out of this scope. And we especially learned 6 months ago in July that in 2008, a secret decree had been adopted that allowed intelligence services to do mass surveillance through underwater cables, so international mass surveillance. Without, of course, any control or anything. I mean, no legal framework more than a secret decree. So we had, as you know, those terrible attacks in January last year. A few days after, the government announced a new intelligence law to replace the one from 1991. It had been in preparation for at least 2 years, but probably the government thought that it was a the good moment for passing the law without any opposition and under an emergency procedure that does not enable lots of public debate. So main problems of this law that was adopted in July finally. First of all, the scope is very broad. It addresses terrorism, of course, but also economic espionage and all European and international commitments of France, which basically means everyone and everything can be targeted by within this scope. So one of the problems is that not only the intelligence services are allowed to use the technical, the surveillance technique, but also numerous police services. We have a very long list of police services that can implement such techniques. We have also a broad and intrusive surveillance technique, some targeted ones, like keyloggers, microphone cameras, but also like mass surveillance one. And we have the possibility to have IMC catchers or the so-called black box that are implemented, deployed by hosting services and ISPs, and the objective is to detect suspicious activities on electronic communication, etc. And we have absolutely no information on how and when and where those black boxes are deployed. So this is absolutely not transparent at all. So one other issue is the data retention period, which is very long and absolutely not compliant with the digital rights ruling from the European Court of Justice. But it seems that the government doesn't care a lot. We have also no real protection of protected professions like journalists, lawyers, members of parliament as well. It's the law says that they're protected, but in fact, when you look at you see that there is no way to protect them really. So this is very fake. So regarding the oversight of the intelligence services, who have very broad powers, we can say that first of all, the main problem is that there is absolutely no judicial power. So it's completely circumvented. It's not involved at all during all the process. The government set up a new oversight committee, which is for the CNCTR, which is the National Committee for Control of Intelligence Techniques. It's this committee has a consultative role only, which is nice. The Prime Minister gives the authorization to the intelligence service and has the right to bypass the advice that is given by the committee. So the real power is to the Prime Minister. The committee can control what is done by the intelligence services, but if there is a disagreement with the government and with the intelligence services and with what is done, then it can only ask to the Council of State, which is our highest administrative court, to settle the disagreement and to decide what to do. So if there is a problem, then there is a very long process to decide if we have to stop this, what is happening or not. So no real control by the independent committee which has been set up. And I say independent, but in fact the head of the committee is appointed, of course, by the government, and the current head of the committee is a former member of one of the services of the Prime Minister dealing with defense issues. So, I mean, he has to control now what's doing the government, and we do not know exactly how independent he is. Of course, there is very weak possibility for citizens to challenge the state about illegal surveillance, because defense security can be opposed at each step of this case court, and of course the process is not done under judiciary court as well. So the problem is that we would need more judiciary court to provide as a safeguard for individual rights. So, well, now we have this for French intelligence, but we have also, well, since October, we have an international surveillance law that has, which is interesting because it's now called surveillance law and not intelligence law. Okay. So this, the main powers given to the intelligence services is, of course, to still have mass collection of data through underwater cables, so still mass surveillance without any control, ex-ante control, however, because the opinion of the committee is not necessary at all to set up international surveillance techniques. So there is nothing to do a priori, well, ex ante before. And then the controlling body can just check what is done and tries to discuss with the government and intelligence services if there is a problem, and then if the government doesn't want to stop anything, then the committee can ask also the Council of State. So no control at all or very weak control for all surveillance law in France. The problem is that there is a fake of control and fake of data retention periods and fake of limitations. So this is very difficult. This has been very difficult for us to stop the process just because the government said, okay, look, that's great. We give limitation and we give a control from an independent body. So what are you complaining for? And, well, that's it.
Fantastic. Thank you very much. Having heard briefly from the French, I can already see people shaking their heads, so we will come back to you in the questions. No, there were several head shakes, and I look forward to the debate. I'm sure it'll be very interesting. Ian, would you like to jump in with a British perspective?
Sure. I'll try to be brief to maximize time for discussion.
Thank you.
I'm going to talk about transparency both in the foreseeability and accessibility of the law, as Douwe has mentioned, and also in terms of practice of use of some of these powers, and then just mention very briefly, I think, some interesting thoughts some UK authors have had about in more involvement of national data protection authorities in oversight, which I think could give us interesting options. So first of all, I did some work over the last couple of years with American and European colleagues looking post-Snowden at the various reform proposals there have been for overhauling surveillance law. Of course, when we're hearing this already, all the different areas Agnès was talking about, all the different concerns that people rightly have, and looking at that, doing that exercise of comparing in particular the necessary and proportionate principles that civil society agreed, the company reform principles that some large internet companies have put together, President Obama's review group, and the European Parliament's report post-Snowden. I'm not going to go through them at all. Our report is online if you want to Google it. It's called Towards Standards for Multilateral Intelligence Gathering. I think something along those lines. I'll tweet it after this discussion. But some of the factors we looked at in these proposals, not just obvious ones like data retention, which of course is an enormous issue in the UK, but some of the aspects that really were very under-discussed, I think, before Snowden. So on bulk collection under the conditions on which it can happen, how data can be used, data mining, something Douwe has written a lot about, of course. What data is collected is only the start. How that data is then fed into, perhaps often very opaque, even to the operators of the data mining technologies, machine learning and so on, where the machines themselves are learning from the data. They're not just following simple pre-specified rules from their operators. The extent to which there's judicial control at the different stages, the disclosure of legal authorities and interpretations, that had been a big issue where not just the US, I'm not at all picking on the US here. In fact, we conclude in our chapter the US post the Obama review and presidential policy decision and USA Freedom Act now has one of the most transparent legal systems and frameworks, I think, in this area. But to use the notorious example that I think the term relevant in the Patriot Act had been interpreted by a court, by the Foreign Intelligence Surveillance Court. They had agreed with the US government that could be used to gather all US domestic phone records. It turns out, after all of the talk of transparency in the UK, I mean, unsurprisingly, I think you can look at any of the Snowden programs and say, well, at the very least, the other Five Eyes partners are likely to be doing this. There would have to be a good reason why they would not. And it turned out, actually, under very opaque provisions of UK law, to do with vague national security directions that could be given by the Secretary of State to telecommunications companies. Our Home Secretary told Parliament just a few months ago, it was the end of last year, wasn't it, Julia? Yeah, that, oh, surprise, the UK has been doing this as well, despite having a really quite comprehensive already Regulation of Investigatory Powers Act, which sets out all sorts of other powers that are used. It turns out not only that was just one of 189, by the way, secret directions that the Home Secretary chose at that point to disclose to Parliament, which the Interception of Communications Commissioner's Office had said in recent reports, that's the watchdog for the use of these powers, they don't oversee, they were not, they're going to in future, they are to some extent and they will more firmly in future oversee the use of those powers. But I think it was their 2014 report, that office did not even was not even able to obtain a central list. I don't think they could find one in government anywhere because different secretaries of state were issuing these directions without any real centralized consideration of them. So making public these kind of things, the rights of subjects of foreign surveillance, notification of data subjects, data minimization, onward transmission, purpose limitation, transparency, oversight. So a long range of factors. I think as we're getting more transparency on these rules in a number of countries, you can then do the interesting comparative work of the kind that this panel is particularly discussing, that Douwe and colleagues have been doing, that others have been doing, because of course countries can try to learn from each other's best practice. Or worst practice. There has been a limited amount of that in the past. There is, I forget the acronym, but there is a biannual conference of intelligence oversight, intelligence watchdog. Watchdogs get together. It was hosted in London a couple of years ago, and I spoke at that one. But it's, in general, those are not open to, they're by invitation only. I was only at the specific panel that I was invited to speak at. All of that said, I think in the UK we've had an interesting debate and reform process post-Snowden, and actually, those of you who are not British and following this, you might find it very interesting to look up a draft bill which is now being considered by Parliament called the Investigatory Powers Bill. There are many debates that can be had about the powers in that bill. I'm not going to go into it now, but at the very least, it much more comprehensively than before sets out the framework and the various powers under which government can do some of these kind of collection, including national security, not only law enforcement. That's something you often see in debates. Okay, we'll talk about the law enforcement side, but the national security side is just too sensitive. As Douwe said, that's very hard to square with rule of law in the meaningful sense, and particularly with the European conception of foreseeable and accessible law. So that's on the law side. On the practice side, I think Jo Cavan is in the room from the Interception of Communication Commissioner's Office. I hope I don't make her blush when I say, actually, I think that watchdog has done a really great job in the last couple of years in making practice much more transparent of the use of some of these powers. That office, again, so many acronyms, The acronym is IOCCO, I-O-C-C-O, if you want to search for it. They publish now bi-annual reports where they set out in quite a bit of detail, for example, not just, as has happened for a long time, statistics on the number of interceptions and metadata requests, or they're called communications data requests under UK law, confusingly, but breaking those down by most recently the different purposes for which those requests were made, so looking at catching people selling drugs. Drug trafficking, for example, is one of the unsurprisingly quite significant areas that these powers are used for. The kind of application process that is gone through, where errors are made, where they came from. They're mostly quite basic errors like mistyping details of phone numbers or IP addresses or addresses that are going to be under surveillance. So you can see a lot more information coming out of there. A lot of this takes really dogged work, because it turned out, for example, in the past, a big issue was, whilst there was some data about how these powers were being used, it had to be previously dragged out of government departments. So a campaign group called Big Brother Watch in the UK went through a big exercise where they sent Freedom of Information Act requests to all of the police forces in the UK. They really had to battle with them, because many of them initially rejected the request and said it wasn't covered by the Freedom of Information Act. Actually, when I went through that process myself a few years later and asked for follow-up data, I got similar rejections, even though the precise same questions had been answered about previous years for Big Brother Watch, and I sort of gave up at that point. But it turned out even then that the figures that had come back from these 50-something police forces and government departments were not comparable anyway, because they were counting in different ways. And, you know, for example, some of them might put in one request for data which covered multiple subscribers, but count that as one request. Whereas, thanks to the Interception of Communications Commissioner's Office working on this issue, there's now not much more, for the first time there is a statistical code of practice that all of these different government bodies with these powers have to follow to set out much more precisely how the powers are used and make the data comparable. So I think that's a very positive thing. Final point. Within the EU legal framework, of course, the EU does not have competence over national security issues. However, that doesn't mean that the member states can't choose to involve their national data protection authorities in at least some aspects of oversight of intelligence agencies. Someone who's well worth reading on this issue is a UK data protection lawyer called Chris Pounder. And he's written a number of proposals to say, okay, well, you could draw out specific parts of the data protection principles that you might give limited authority to the DPAs to oversee. He suggested, for example, that intelligence agencies should have to commit to purpose limitation, making sure personal data are processed in a way that's not incompatible with the national security purpose, that personal data are kept no longer than necessary for the national security purpose, and that personal data be kept secure and only transferred if there's a substantial public interest in the transfer. So that's, I think, a nice spot for me to stop, because all of you in the audience who are interested in data protection might have ideas about how to bring these two different frameworks together. Thank you.
Thank you. Julia, would you like to wrap up and also provide your last case?
Thank you. So I've changed a bit what I'm doing, being the last speaker at the end of a long day, and I thought I'd just sort of step back a bit and offer some reflections, sort of a roadmap to some extent for this emerging rubric of the academic activist. Because as I wander these halls and see all these good and earnest people following enormous amounts of material, I feel in many ways some of our efforts get splintered by the diversity of the issues we try to address, and there could be some more consolidation. And one of the themes that we could really consolidate on is the theme of this panel, because transparency, accountability, oversight, these are issues that no matter what perspective you take, we can all do with more information. It means that we debate the facts, not philosophical perspectives on issues like surveillance. So I have 5 points. The first is that we should choose our targets. There is a lot of law and uncodified law practices in different jurisdictions. We've been looking in this study at some countries in the global south, and that builds on work that Privacy International has done, really impressive work in many jurisdictions. And I think that if we focus on the jurisdictions that we work in and then others that are used as leverage in other jurisdictions, I mean, the Five Eyes is a remarkable institution that works to use pressure points in particular countries to advance agendas. The DRIPA bill, for example, that was introduced and passed over the course of 3 days in mid-2014, happened at the same time that there was a Five Eyes meeting in London. The Australian metadata bill was used at the same time that discussions were being had about what Western countries would do and which weren't yet public. And so there's a lot of coordination, and I think that as academics and activists we can work to somehow counter that. One way to counter it is to put some roadblocks into that process, to stall to some degree. The IP bill discussion that's happening is much more informed than that debate about DRIPA, purely because we have more time to coordinate, and people are aligning their resources so that this fabrication of the privacy lobby, which is a few very earnest and good people from Liberty, Privacy International and so on, can actually say, well, we're relying on a consolidated resource of case law that's developed over years, of positions that have been developed by multiple people. So I think that some coordinated action and selection of targets so that we focus on what we know best. There's some sort of distraction here that a lot of people say, well, until we reform the greatest surveillance power in the world, the US, we can't really move on other countries, and I think that some people get distracted by that, and we can always make improvements so that you have best practices to point to. The second one is to penetrate barriers. One of the pieces of work that Douwe has been really leading is to look at categories like judicial oversight, which everybody wants judicial oversight, and to say, when is judicial oversight effective? There's a big difference between ex ante, ex post, if it actually involves some inquisition into the merits. Here, for example, I worked in Australia in quite an admirable oversight jurisdiction, which is the Administrative Appeals Tribunal, and the members of that tribunal can remake government decisions. We had people who had their passports removed on the basis of an adverse security assessment. They came before a tribunal of judges and ex-officers who would say, take away everything that's redacted here, we want full evidence. We hold the Director General of Security in front of that panel, and we're able to remake decisions. So I think judicial oversight, great banner slogan, but it has variations. And there are others like this. Bulk collection, that fantastic euphemism of mass surveillance. Malcolm Rifkin, for example, can claim that, oh, well, we don't bulk collect everything that passes the internet. Well, if you don't count video communications that are, people streaming Netflix, well, you're not tapping the entire net, but how much communications are you tapping? So these phrases, I think when we work together, it's really useful to be able to penetrate that. Another one that's just emerged in the UK is the judicial double lock, for example, and this kind of language that creates a false sense of security. The great one of, oh, well, we want encryption, but encryption that you can decrypt, it doesn't really take us very far. So I think penetrating those barriers and moving to the detail beyond the banners would be really effective. The third thing is to beware of decoys. My personal opinion is that the encryption debate is an utter red herring at the moment. I think that we could waste a lot of energy refighting old debates. I mean, unless there's some way to stop geeks in building new modes of encryption, you can't ban encryption. I think that behind that encryption debate is a much bigger one, and we should, I concur with Mark Rodenberg said in the previous panel about how we should make sure we're having the bigger debate about data collection and not just getting into a narrow debate. I mean, the fact of the matter is intelligence services have more modes to tap communication than they've ever had before. There were pragmatic limits until 20 years ago, 30 years ago, with you couldn't steam everybody's letters. You could put a wiretap, but you couldn't tap everybody's communications. And there's now some technological affordances that I think we need to limit, and there could be a very strong role, in fact, looking at the secrecy of communications standards that have been developed over a long time to bring back you know, the sort of decoy debate of, oh, we can't get to every single private space. Well, you've never been able to get in people's bedrooms, into public parks, and, you know, into underpants. So the fourth is, and here I steal a point from Gus Hussain of Privacy International, is to reclaim from national security, real security. And here, and we just heard in the French case, suddenly national security slips into, oh, industrial espionage, and we better make sure that we're protecting France's national interests. And security here, we face I think we really are at a precipice of many more points of vulnerability and weakness with ubiquitous connectivity, Internet of Things, and so on. And every time we create vulnerabilities in that network, we create many more weaknesses than those that purely the terrorists will exploit. So I think that the very kind of a mature approach to security that takes it beyond national security, and I really think there's some here some of our allies, and my fifth point is about working with and understanding our allies. The courts are really, I think, pushing back a bit on this national security thing. I took a lot of confidence from the David Miranda decision in the Court of Appeal in the UK, which was saying you can't just use this banner of national security and use it to get away with a lot. And here, actually, I mean, I think that there are some activists would consider many in intelligence you hear the argument about the deep state and so on. I think that many who work in intelligence want those sorts of actual limits on prescriptions on national security so that the work can be targeted and so on. So I think a real fight for security and thinking about it in terms of the points, and a lot of this is actually happening in the commercial and private sector of capabilities of technology. You know, the debate that's already seemingly lost about drones, about facial recognition, about multiple technologies where we create many more security risks. And the final one is understanding allies. And here I have one point where I think we could have more academic and activist engagement. This is work that Ian's done and with Matthias Vermeulen, is that actually if we really wanted to restrain the sovereignty of states on surveillance, you do need to engage at an international level. And here I find it quite unfortunate that many in the internet technical community are very willing to trash institutions in the United Nations, for example. I worked at the World Intellectual Property Organization, where the same delegates worked on one side of the street and said, let's regulate the internet, and walked across the other side and said, the ITU is, you know, the evil institution. So I think that if we really did want to limit sovereignty of states, there's provisions, say, in the ITU constitution that could put a limit on making sure that you have judicial oversight of surveillance, and that there's a real opportunity there. And then the final ally, where I really think, I mean, it shows that we have reached quite a state of disaster, is the courts. And, you know, there's a lot of great stuff coming out of the CJEU and the UK, and that the more that we can use those in the same way that intelligence services are using moments of, you know, the Paris attacks to put forward, oh, that bill that's been sitting in the bottom drawer for 2 years with nobody having an appetite for it, the more that we can sort of consolidate those cases that are being developed and that really show that we, under the rule of law, we need proper transparency and accountability and oversight of surveillance, the better. Thanks.
Thank you. And to move straight on to the people in the audience, I saw already several people shaking their heads, so if any of those would like to ask a question, now comes your time. Please, do you have a microphone at all? Yes, there's a roving mic coming right to you. Seriously, if you can manage to shake your head during a presentation, you can also manage to ask a question. Please.
Come on, head shakers.
Okay, so
we believe in you.
I wanted to go back to this issue of ex-ante judicial review, and I'm curious if either the UK or France adopted such a system, what kind of court would do that? And here's why I ask. I have been trying to research where the US came up with the idea that a search warrant must be issued by a court as opposed to the Home Secretary or the CNCTR or the German G10 Commission, because it's actually quite unique. There really aren't that many other countries, including our closest allies, that require that ex-ante issuance by a court. And I don't honestly know how we decided that a warrant should be issued by a court. It's possible that because we didn't have a home office or anything close to it until World War I, and, you know, we didn't have an intelligence agency until 1947, that there wasn't anyone else around to issue warrants, so we figured it should be a court. The Fourth Amendment is typically most heavily invoked in a criminal proceeding, and that's because we have the exclusionary rule, which I don't think either the UK or France have. So, you know, it ends up being tested. I mean, some of the best experts on the Fourth Amendment in the United States are the National Organization for the Reform of Marijuana Laws. Nobody knows the Fourth Amendment like a pot smoker. I mean, they know it cold. So, you know, if we are not seeing a whole lot of judicial review of U.S. intelligence collection, it's possible that because the exclusionary rule is the main means of invoking it, that, you know, it's just not coming up on people's radar screen. It would actually be hard to bring a lawsuit based on your sense that someone is spying on you. You know, there's usually an interest at stake. So if France or the UK or everyone in Europe, if the European Court of Human Rights ruled, needed an ex-ante judicial requirement for the issuance of search warrants or intercepts, which court system would that be? How would you see that playing out?
Should we gather one or two more questions before we get some responses? Please, in the back. Oh, there's first in the back and then, of course. Glad to see some of the head shakers are starting to respond.
Tobias Morschuss from Datenschutzraum Germany. I'm interested, how should transparency and oversight work if in the first case 99% of the people that are targeted never get to know they were targeted? Then the people that know they were targeted never have a real, they can go to court, but they never get real consequences out of it. And if you have an independent oversight board, this oversight board looks at the primary target, but if you do surveillance on someone, you also infringe on the rights of everyone that is communicating to this person, and who looks in the rights of these persons, and how can there be a real oversight over something where nobody really knows what's going on, and where the intelligence bodies lie to everyone, even to the oversight committee?
It's a challenge, but not an impossible one. Please, over here. We have one more question here, and then I think we'll get some answers. There's a question here. Fantastic, thank you.
Thank you very much. Mario Tamer from the Fundamental Rights Agency. Thank you very much for the panelists. I had listening to you, in fact, I was wondering where we should put the limit. We've done a survey, a mapping, let's say, at this stage of the surveillance legislation in the EU. And I understand where you're coming from, for example, Professor Korff, putting into question the actual existence of the surveillance methods. Where our starting point was, of course, their existence, so we pushed the cursor much lower. But starting from there, when I saw the evolution, for example, in the last, well, let's say in post-Snowden terms, and I think that's where Ian Brown is saying very rightly, what's happening now in the United Kingdom, the presentation of the bill is quite incredible as a gesture of transparency. And that's where I want to come to the French situation, because you were extremely critical about the process. I'm not here to defend anything, but at least when you look at the legislation, it has the great added value of presenting the full spectrum. And now to come back to the ECHR case law, at least it would pass the test of the legality. So we can be critical about the secret laws, and again, I would like to have your opinion about this reference to the 2008 aspect, because I'm still unclear where it was so secret that it was not even existing, or whether it was really not done without any legal framework, for example. And I know that your organization has brought the case in front of the Council of State, so I'd like to hear about the outcome. But for me, the full movement of the presentation of the legislation is at least something that should be looked at very closely. That's the first point. The second point is linked to the oversight mechanisms. I mean, here again, our survey shows that there is a general very big weakness. I had no doubt about this. But again, how can we already nail, for example, the French Commission that has 6 months of existence and absolutely no or little idea of what is its actual work so far? So we can base our judgment on the past commission, but now we have a stronger commission in France at least, and we could at least look concretely at what has been done. For example, on one very important point that Professor Korff mentioned, it's the access to data, which is very important. My understanding is that the French Commission has a constant access to data, which is something that at least compared to other commissions, it's not the case. So just wanted to clarify these 2 points. Thank you.
Fantastic. Thank you very much. Would the panelists like to respond? Ian, please.
Partly responding to Mario's point and also to Julia's point on allies, which I agree is very important. I think another one is the European Parliament. We didn't talk so much about, but I think not just the initial Libe report that was published in the last Parliament, but the work that Libe is doing, it's certainly not easy, but to try to better coordinate the activities of the national intelligence oversight bodies, because clearly, I mean, one big advantage the US government, the federal government has is just scale compared to the 28 member states. And although the UK can do a relatively sophisticated job in terms, you know, the UK Parliament does have a reformed intelligence and security committee, although it's interesting if you compare the report they published on Snowden with the one published by David Anderson QC, who was under DRIPA, this act from 2014, was asked to do an independent review of all of these powers. Actually, Anderson's report is nearly 4 times longer than the Intelligence and Security Committee report. I mean, they cover slightly different things, but Anderson's is much more comprehensive. So I think the jury is still out in the UK on how well that parliamentary oversight function works. But I think it's really important that the member states better coordinate. Whether they can do that under the current treaties, I don't know. I suspect it might be a case of, 10 plus years' time as the Eurozone federalizes further and intelligence cooperation becomes more of a competence of that Eurozone. That will be yet another reason that the UK will never join.
Oh, Lord. I was hoping for some optimistic points. Douwe, please.
No, more. Well, no, actually, I'm trying to be positive. What is a good oversight system and what is the role of judges? I think, given that by necessity, the activities of national security agencies have to operate to a certain very high level of secrecy, you have to have the right mix, and you have to have checks and balances in all the places. The starting point, and I'm talking as a constitutional ECHR lawyer, must be clarity and foreseeability of the law. And I think there has been massive failure in that respect, in that many security agencies in Europe and in the United States have been doing things that nobody foresaw and nobody realized they were doing, although they pretended that both at the time and later that what they were doing was legal. I think that has caused an immense distrust in the security services, and it has done them a great disservice. If they want to creep out of that hole, the starting point must be clear, foreseeable law. As the Strasbourg court said, of course not every individual has to realize in advance that he's going to be under surveillance. But every citizen should know in what kind of circumstances he or she can reasonably expect to be under surveillance, and also when the state should not put him under surveillance. That is a minimum requirement of the rule of law, and there are 2 elements to that. One is the law must be clear, and the second element is the security services must stop trying to wriggle out of those constraints. If they think the constraints are too much, they must go back to Parliament and ask for more powers, and it must be democratically discussed and then given more powers if it is democratically acceptable within the international framework of law. Once you have the framework, you need different systems of oversight. For one thing, the oversight bodies that we've had, parliamentary, expert and whatnot, very often have been inadequate. They've either been captured, either they have been cronies of the government or of the security services and useless, or they've been captured while in office, and that goes for an awful lot of politicians as well. They were in awe of the security service and wouldn't dare to criticize anything they did, or they were incompetent, and very often it was all three of them. That must change. We want oversight committees that have full access, that are democratically legitimized, that have the technical capability of understanding what the security services are up to, and that report publicly in meaningful ways on what is being done in our name. That is not impossible. Then you also want judicial oversight, but I have hesitations. Yes, judicial oversight will also, it's important because it provides a check. But things should be recorded, they should be argued, they should be minuted, the activity should be logged. That is, in a way, the more important issue. And then we can trust the security services. I put it in a slide somewhere else. The spies must learn to spy by consent, just like in the UK, the police always say they are policing by consent.
And yes, would you like to respond as well?
Yeah. First of all, on the committee access to the on the role of the committee and the new committee that has been set up for the intelligence law is quite similar to the one that existed before. We had one since 1991. What we could say, for example, is that when you say that the committee has full access to data, this is one of the points that we do not agree with. We asked for a full centralization of all data within the committee, and this has been refused. And this is not the case now. So, and the former head of the committee, former committee, asked this as well, saying that this was the only way to make sure that the committee could have a real access to data, to all the data, and a real control of what is done. Right now, it's not centralized to the CNCTRs. And this is quite easy for services to give almost full access to data. Of course, the committee can go whenever they want to the services and check what's happening, but you never know if they really want to hide something, it will be possible. I mean, so it's not full access to data. We can already know something that the head of the former committee said that within the last year of his committee, of his mandate, he was very concerned because the government starts to bypass more and more his advices, which was less the case before. So it was like we can anticipate that this would happen more and more. So I mean, of course, we do not have the CNCTR is not more than 6 months, but we have some elements to say that this is not a really protecting oversight committee, I mean, for us. For the regarding, I'm just going to make last reply regarding for people that want to know if they're under surveillance, then in France now, everybody can ask the committee if they are under surveillance, and the committee can say only this is all right, or there is a problem. They won't say yes, you are under surveillance. They will say there is no problem with you, or there is a problem with you, or with your case. I mean, So, and if there is a problem with your case, then they would say probably, okay, we've done what is necessary to make the process more normal. And if you're not happy with the reply, then you can go to the Council of State, which is an administrative court and not a judicial one. So at no part of the process you will have access to a real judicial power or court. So this is, but of course there is absolutely no way the scope is so broad and there's so many things to do that you can absolutely don't know if you are going to be under surveillance or not.
We have 2 more questions, one here at the front, and then 2, 3. Okay, the microphone. We're going to try and wrap up as quickly as possible.
Okay, thank you. I'm Hartmut Aden from the Berlin School of Economics and Law. I just would like to follow up on what Douwe Korff told us in the last round. So it's nice to have a legal framework and more laws in states, as even in the UK or in the US. But then the next step is to look at the quality of the laws. And I think this is really a crucial point. In my opinion, also the French case is showing that. I myself was recently involved in the reform of a regional secret service in Germany, and it became immediately clear that there is a legislation, there is a law, but this is very complex. And in the German case, this has to do with data protection case law from the 1980s by the Federal Constitutional Court, and the reaction was to make very complex laws that seem to be very rule of law-like, but if you look at these laws in detail, they allow everything because they are so complex. And I could also quote examples from EU law, from third pillar laws. It's basically the same problem. So I think in a comparative perspective, we should develop tools in order to evaluate the quality of laws.
Very good point. We have another question at the back here, and then one at the front, and then there's a list if there's no further
Hello,
questions.
Thorsten Wetzing from the Stiftung Neue Verantwortung. Just a brief comment, because it was an interesting question you raised about where did the ex-ante judicial order question came from. And in Germany, this is the debate now as well. And I think it's just briefly nice to make this comparison between the rule of law and fundamental rights. Paul Nemitz mentioned that as well. If you think about power wars, the Savage book, look at Obama, there was a clear trend to say, we can do a lot on the rule of law, but we don't have to do that much on the fundamental rights, because it's, in terms of sanctions, you can beef up parliamentary ombudsmen and oversight institutions, but they don't necessarily have the sanctioning power. Fundamental rights power, as the G10 Commission, for instance, would be you have to now cease this operation you're doing. And this, I think, it goes a long way to explain the difference.
Fantastic. That's a good point. Thank you. And last, right at the front. Lady right in the first row. Thank you.
Does it work? Yeah. Does it work? Yeah. I'll stay seated if that's okay. My name is Anna Drosna. I work for the Law Society's Brussels office. So we work for this is a professional body for solicitors. And actually we work with the 3 jurisdictions in the UK. And I'm very glad that one of you mentioned lawyers and the issue of professional secrecy, because this is where the rule of law and fundamental rights meet really, really well. The right to confidential communications between a lawyer and a client is actually a foundation of proper administration of justice. And there were cases in Europe, specifically in the Netherlands, where lawyers were actually spied on. And this raises the profound issues that really there is a problem, because if it happens once, fair enough, but we don't know now if it happens once. What if it happens on a more massive scale? What if your communications with your lawyer on whatever issue, it may be your divorce case, or it may be a mergers and acquisitions case, which has profound political implications and economic as well. So I'd like to, thank you very much for mentioning that, and just maybe some of you had heard about the case yesterday actually, because the lawyers from that firm was here as well. I have also a comment about the judicial oversight, because a lot of you mentioned about the laws, quality of laws. Yes, I know I have to be brief.
I'm sorry.
But it's also the effectiveness of public institutions as well. And it's fine that we're talking here about the UK, France, Germany, but there are other countries and they are younger democracies. And I think in there, the debate about the role of the courts and how that judicial oversight would work is actually quite important as well. Thanks.
Thank you. And I'd like to give the panelists, perhaps, shall we say, 30 seconds each to wrap up? Douwe, do you want to start very briefly to respond to those questions and to wrap up? 30 seconds.
Well, I think the assertion of the rule of law is crucial, but you need checks and balances at different levels. So you need judges ultimately decide what is lawful, but you need clear law to do that. If the law itself is incomprehensible, then it is full of loopholes by definition. So, and the law has to be, I must say, Strasbourg has spelled that out quite well. And I would stick to that as the guideline. And I think both for lawmakers and for judges, that is a reasonably good set of guidelines. You need clarity of law, good oversight, transparency, because judges are not always the best at checking what exactly is happening. They haven't got the technical capacity. So you need input from the oversight bodies so that the judges can do their work.
Ian, do you want to jump in?
Yep. On the legal professional privilege case, in the UK also, this is one of the very few adverse rulings there has ever been against GCHQ, was precisely to do with that they were wrongly holding legally privileged material, weren't they? I forget the name of the case. I think it's Belhaj related, yes. I mean, clearly the right to seek a remedy in court is a critical way of testing the quality of law, and we've seen absolute overdrive in the UK.
We are.
Yeah.
Thank you.
Overdrive in the UK Investigatory Powers Tribunal, thanks to an NGO, Privacy International, bringing case after case after case after case after case, and actually the IPT has really, I think, woken up and started doing its job, which it was not doing very well before.
Fantastic. Julia?
One thing was just on Ian's point about parliaments being important allies. The Interparliamentary Union, established 1889, had 138 parliaments of the world commit to necessary and proportionate principles for surveillance. That's a really important thing that we should hang our hat on.
And last of all, just because we put this panel under a specific title for a specific reason, I think we've shown quite well that while we previously discussed these dark ages, like we're not in the 19th century anymore where we need to pretend that the law doesn't apply somehow to the powers of intelligence agency or to the powers that exist. And we can now have a serious conversation about where powers begin, where they end, and how they're governed. The boundaries of the law are slightly different than those that we think. Thank you very much for attending, and look forward to seeing you again soon.